Muted your microphones. I am absolutely delighted to introduce you to Maryland's Deputy Secretary of State, Mr. Luis Barunda. Secretary?
Good morning, everyone. It is a pleasure to be with you this morning. Assistant Secretary Smith and Administrator Schlein, thank you so much for your leadership. This is obviously a new way to communicate to Maryland's thousands of notaries, and we're excited at the opportunity to find and provide this new service to you, although this is not the first town hall that has been provided. It is a great new way for us to communicate with you, and it's been through and under the leadership of Assistant Secretary Smith that we have implemented this great new communications tool. So thank each of you for taking time this morning to take advantage of learning, and it's such an important part of what you do. This is taking our service to our notaries to a new level. And so I'm going to get out of the way because I know that there's a lot of information to cover today. But once again, thank you so much for being a part of Maryland's notary, professional notaries. And so we're going to turn it over, I think, to Administrator Mike Schlein. So have a great day, everyone. Thank you.
Thank you so much, Mr. Secretary. We're so grateful for your joining us this morning. So once again, the recording of today's town hall and the PowerPoint will be posted on the Secretary of State's website under the Notaries tab. Please know that the content and the presentation is provided today for informational purposes only. It is not intended to be legal advice. Again, as we begin, please mute your microphones, keep your camera on if you like, and without further ado, please allow me to introduce our fabulous Division Administrator, Michael Schlein. Mike?
Thanks, Kathy. Can you hear me good?
I can, thanks.
All right, fantastic. Welcome, everybody. Good morning. Today we have a lot of material we're going to try to go over: the Notary Handbook, the law and the regulations. It's an overview, emphasis on the overview. There's a lot of stuff in the handbook. We're going to try to cover all the topics today at a high level. I think if there's anything you take away from today, it's view and read the handbook.
Yeah, you know, Mike, that's a really good point. And we're going to have a little bit of this back and forth during the session. And I'll share that, you know, we've had some questions actually about the town hall. And the town hall is not a substitute for the course of study. That was implemented in law in October of 2021. It is simply an outreach to our notaries public and those who are interested. And know that those who are in attendance today are not required to be in attendance. And I'll just share one other thing, Mike.
Yep.
The chat box will be open for anybody who would like to place a question there, but I'll ask that only questions are placed in there by our participants. Please do not, let me repeat that again, do not respond to the questions that are placed in the chat box. It's really critical. Our notary officers will announce those questions at the end of this town hall, but it can be very confusing for our participants if other participants enter answers. The answers that will be provided need to be from the Office of the Secretary of State. So again, notary officers are available at SOS to answer your questions and to provide information only, but cannot provide legal advice. For legal advice, individuals should contact their legal counsel who specialize in that particular area of law. Sorry, Mike, whatever you said there triggered that. I wanted to share that little reminder. Back to you.
Yeah, that's a great point, right? We're trying to convey the information and convey it as best as we can. And we'll take questions at the end that are in that chat box. Our notary officers may even respond to your question in the chat box as well. And for some of the frequently asked ones, we'll cover them at the end. But yeah, please let us respond to those questions. We don't want to have anybody unknowingly giving bad information or answers out to questions that are answered in the chat.
And amazingly, that has happened in previous town halls. Folks have unintentionally given wrong information. So please, please, please do not respond unless you're a notary officer.
It has. We want to get good information. That's why we're here today. And like I said, if you learn anything else from this town hall, it's going to be a lot of information we try to cover today.
And I bet a lot of questions will actually be answered as the presentation unfolds.
Right.
So you may want to even hold off on asking those questions until after the end of the presentation.
Right. So that handbook has a lot of good information on it. Just an overview of what we're talking about today. Brief coverage on how to apply for or renew, how to apply to become a notary or renew your notary public commission. We had an entire town hall on this subject back in the beginning of February, and that's posted on the notary page on the Secretary of State's website. Just like this recording will be posted there within a few days of today as well for those that couldn't attend. So if you're looking for detailed information in this type of format on how to apply or renew, go to that town hall and review that information. We're also going to talk about guidance regarding, scope of duties and responsibilities, understanding the handbook, different statutory references regarding the law, and the regs from which this information is pulled also appear in that handbook. And it's good to know that. So the handbook has citations of law and the regulations, so you can look up if you need to look it up, or you want to look it up further, why we're saying what we're saying in that notary handbook. A lot of topics here, 13. We're going to move through them all. Like I said, we're moving through here at a high level. The details behind all these subjects are in that handbook and expanded upon in that handbook. So I encourage everybody to go to that handbook on the notary page of the Secretary of State's website and view that. If you don't already have it, it's something you should have and understand and be familiar with. And this information is say relatively new. October 1st, 2020, a lot of items in the law changed, and a lot of things are different now than they were. So notaries that have been a notary a long time, everybody always says, why should I, or why do I need it? Well, you need to reread it because things do change, and the law is fundamentally different than it was prior to October 1st, 2020. So good to be on here and to review, and also important to reread that handbook. It's easy to forget. There's a lot going on in everybody's life. Everybody's busy. Everybody has a lot happening. It's good to stay refreshed on what you're doing and why. So a quick, what's a notary public? Well, notary public is an officer of the state, right? You're an officer. You get a commission, and you go take an oath of office as a notary public. And so you're an officer of the state. You're allowed to hold another public office if you're a notary public. In other words, I work for the state, but I can also be a notary public. Or maybe I'm an elected official, but I could also still be a notary public. I could, if I'm a notary public, I could still hold another public office. Held to the same high standards of public trust as other appointed and elected state officials. Responsible for knowing that the law, which you can learn about in the handbook, where it covers the law and the regs and some other guidance. There's a lot of information on our website as well. Notaries public are civil officers. They have a legal responsibility to be in compliance with the law and the regs regarding notarial acts. Should not advertise their notarial services under a trade name. What does that mean? I'm Michael Schlein. If I'm a notary public, I am Michael Schlein, notary public. I'm not Best Notary Pros, notary public, or whatever cool name you can come up with for a business. That name on that notary seal is your individual name. So if I'm a notary, my seal would say Michael Schlein, notary public, and we'll cover seals in depth and what belongs on there. But that's what that means. Your individual name is the one you're commissioned under, not a business name. And if you're a Maryland notary, you can perform any of your duties as a Maryland notary anywhere within the state of Maryland. You get commissioned, if you live in Maryland, you get commissioned in the county in which you reside. And if you don't live in Maryland, you get commissioned in a particular county that's designated, most often the one in which you work. But just because you're commissioned in a specific county doesn't mean you can't notarize in other counties in Maryland. If I was commissioned, my office, if I was commissioned in Anne Arundel County, I can notarize in Anne Arundel County. I can notarize anywhere from, Western Maryland out in Oakland down to the Eastern Shore or Ocean City, or as far south as St. Mary's and all the way up to Northeast Maryland. Anywhere in the state of Maryland, I can notarize as long as I'm physically standing in the state of Maryland when I'm acting as a notary. And so who may perform those notarial acts? Well, a notary public, of course, and other certain judicial officials now have notarial powers. Those are judges, clerks, deputy clerks of the circuit court, magistrates that are appointed by the court. So that's a relatively new thing. Prior to October 1st, you had to be commissioned as a notary. Now you can get commissioned as a notary, but if you are one of these other officials that are listed here, you can also notarize. And a notary's signature and title, that's evidence that they are a notary and that the notarial act is genuine. And so there are certain people that can, and if you're not one of those certain folks, you need to get commissioned as a notary public. So coverage here on applying, renewing, commissioning, name change, and address change. Like I mentioned earlier, this is covered in length in another town hall that we had on February 2nd that's posted online. So if you're looking for more information or more details, not only can you find it in the handbook and on the website, but you can also find it in that town hall. To be appointed, you must be 18 years of age, be a person of good moral character and integrity, a resident of the state or employed in the state or have a practice in the state. And if you're living in the state, you're going to be appointed by the senator representing the district in which you live. Certain senators, review and approve new notary applications. Others delegate that authority to us. So it depends on the district in which you live and your state senator. If you live outside of the state, you have to also be a resident of a state that allows Maryland residents working in that state to serve as a notary public in that state. All of our neighbors do allow that. So if you're in a neighboring state and you're commissioned in Maryland, you're allowed to be here because you work or you have a practice in Maryland, and your state allows Maryland residents who work in your state to be a notary there.
And that shouldn't be confused with reciprocity.
Correct.
So because I live in Delaware or Pennsylvania or Virginia or the District of West Virginia or another neighboring state, but work in the state of Maryland and have been commissioned as a notary in the state of Maryland, that does not mean that you have reciprocity and can perform notarial acts in the state in which you reside. That requires that you're actually commissioned in the state in which you reside. In addition to, Maryland does not have reciprocity with other states.
Correct. And an important point there, right? If I am a Maryland notary and I want to become a notary in DC or Virginia or Maryland or Delaware, I have to go and apply in that jurisdiction to be approved to be a notary in that jurisdiction. The
and
other,
of course, as you just stated also, you have to physically be located in the state of Maryland when notarizing a document.
Mm-hmm.
So if you live in a neighboring state, you can't notarize a document in that state. You have to be inside the state of Maryland when notarizing a document.
One other important point here that's new as of this year, in order to become a notary, you must complete the course of study and pass an exam. If you're renewing, you must now complete a course of study. There's a list of approved providers on our website. Right now, there's only one. We anticipate getting more in the not too distant future. Important points that I want to cover there real quick. Everybody always asks, the list of providers, it is a class you pay for. The price is set by the provider. It is not set by us. And folks often ask as well, say maybe I expire a couple of years from now. No, you do not have to take the class now. You take it during the period in which you can renew, which is 60 days prior to you expire and up to 30 days after you expire. That's the window in which you can renew. And that's the window in which you'll want to take the class. You don't have to hurry up and go do it now. You'll do it when the time comes for you to renew. How to apply to be a notary public. Everything with the applications is online now. You go to this page. It's the direct link to becoming a notary, and a couple important points to think about before you apply. If you're applying as a new notary, you're going to get logged out if you're inactive for more than 30 minutes, or for at least 30 minutes or more. When you hit the 30-minute mark, it's going to log you out. That's a security issue. And if you get logged out, all that information is lost. That application is not saved. So make sure you have all the information you need prior to starting that notary application, and know the requirements before you complete the application. There's a good little write-up in our handbook, as well as at that page, if you were to go click to submit a new application, it gives a summary of what's needed before you start. So make sure you review that in advance. Like we talked about earlier briefly, senators approve new applications. Some senators delegate that authority to the Secretary of State's office. So if your senator reviews it, it's usually, we have 1 to 6 weeks here. It's usually between 1 to 2 or 1 to 4 weeks before you're approved. It's at the senator's discretion. And if we are the ones that have had that authority delegated to us, it's usually within a few days. It's really a matter of references responding to inquiries for a new application. And if you want, you can check the status of your application at that page as well. You can go right back to that link and click check the status and type in a little info from your app, and it'll let you check the status of the application. Most important thing here at the bottom of the page, be proactive. Do not assume that we're looking at it or we have it or that all is great. You're just waiting to hear back. If you've submitted an application and you haven't heard anything in a couple of weeks, check in with us, shoot us an email. The email address is going to be at the end of this presentation where our contact information is found. So later on that slide, you can write us an email, check the status. The last thing we want to have happen is you sit around and wait. It gets approved. You miss the email telling you you've been approved. The commission goes to the courthouse and it takes too long to get there and it gets revoked and you got to start all over. We'll talk about that here very shortly. But be proactive. Be proactive. Never assume. Many years in government, I've learned never assume. Prepare. Have this information handy before you apply. Your government issued photo ID, almost always a driver's license or a non-driver's state ID card. So when you're applying, you're providing us, date of birth, home address, phone numbers, and information. And we're looking for a government issued photo ID that has your address. So like I said, namely the driver's license or non-driver ID card issued by the MVA. When you're applying, you can't give us a copy of your passport as proof of photo ID because it doesn't contain your address. We're trying to verify that. Don't confuse that for acceptable forms of ID when you do notarize. That's a whole nother thing. We're just talking about the application process with our office here. Contact information for 3 references. Know the legislative district in which you reside. It's good to know who your elected officials are anyway, right? And if you want to know that, you can go to that link, mdelect.net, and you can actually search using your address to find out who your elected officials are if you don't know already. $9 application fee, $2 convenience fee, totaling $11 online. Payment by credit card, electronic check, PayPal. So new application process, we've already talked about where you're going to go. When you submit an application, we're going to get it. We're going to contact references, or your senator is going to do that. There's going to be a background check. We're going to check your criminal history, civil judgments. One point I want to emphasize here is if you've been convicted of a crime, check yes on the form. No matter how long ago that conviction was, check yes, explain what it was. The easiest way to have a problem on a new or even a renewing notary application is to fail to disclose a criminal conviction. Always better to say what it is, check yes and say what it is, than try to conceal that and say no, even though you've been convicted. And we talk about qualifications. One of those is good moral character and integrity. An easy way to show that you don't qualify is to submit a false information on your notary application. So if the answer is yes, Just check yes, right? The easiest way to get denied is to check no if the answer is yes. Talked about earlier about why you be proactive in checking your application. If you haven't heard anything, when your application's approved, you're going to receive an email from our office, and it's going to contain information about where to go, get sworn in, and take your oath of office and receive your notary commission. You have 30 days from the date of that email to get sworn in and receive your commission at the clerk of the circuit court. And if you do not do that in time, that commission will be revoked. When you get sworn in, there's an $11 fee. This is different from the one you pay when you apply online. And you want to make sure you get there, get sworn in within the 30 days. Failure to appear results in your commission being revoked. That would mean you have to reapply, pay to apply again. Nobody wants that's the law. It's the way it works. We don't want that to happen. You don't want that to happen. Nobody wants that to happen. Be proactive. If you submit an application, you haven't heard anything in a couple of weeks, check in. We'd much rather you check in up front and make sure that it's still pending for some reason and figure out why that is, than just assume we're working on it and not realize that we sent you an approval email. And, sometimes your email inbox may block it, or maybe it goes to your spam folder. You're not checking that as often. So it can be missed.
Mike, that's a really good point. I was just going to talk about spam. It's so easy for information to get caught in a spam folder. And also, the law says you have to be there. You have to go in person to be commissioned within 30 days. Mike, you might want to talk for a second about, folks who have sent a secretary or a coworker or a spouse or somebody else to pick up the commission, and that's not allowed. And why is that? Right? Because these are public offices, and you're actually being commissioned into that public office. You need to raise your hand and take the oath.
Yeah, good point. I know that may seem obvious to most of you. It is not to everybody. If you are commissioned, if I'm the notary, I
think you may be frozen.
I don't have an assistant anyway. So, but if I did, I couldn't send my assistant for that. I have to go myself. I'm the one submitting the application. I'm the one taking the class. I'm the one going to get my commission. I'm the notary. I'm responsible for it, as are each of you individually that are notaries. You have to go get it. You cannot send someone else to get it for you. But when you apply, make sure you have time to go get that commission, because you have to do it within 30 days. Renewal application process looks mighty similar to a new application process. Completed online, same thing, payment. When you submit a new or a renewal application, we're receiving it the next business day. If you were to go do that now, it's going to be in our system tomorrow morning, and we're going to start reviewing it. For renewals, we're also checking backgrounds, right? If you've been convicted of a crime, check yes, and explain what it is. It doesn't matter how long ago that was. We're asking, have you ever been convicted of a crime on your application? Just because if you're renewing, just because it didn't happen in the last 4 years doesn't mean you don't have to disclose it. You still have to disclose it, no matter how long ago it is. Even if you disclose it on your last application, you need to continue disclosing it. The question is, have you ever? Make sure you disclose it. Can't emphasize that enough. And if approved, you're going to get an email that tells you to go get sworn in, just like you did when you applied the first time. You have to go to the courthouse to get sworn in for every commission. So I was sworn in 4 years ago. People ask us all the time, I got sworn in the last time. Do I have to go again? Yes. Every time you renew and you get another commission, you have to go take the oath of office at the clerk of the court and receive your commission in order to qualify to be a notary for that next commission. Every 4 years you renew. Every 4 years after you renew, you're going to go to the clerk of the court and get sworn in after you find out your renewal's been approved. And just like a new applicant, you only have 30 days to get to that clerk of the circuit court to take the oath of office for that renewed notary commission. If you renew, it's not taken but a couple of days tops. to get approved. So if you've submitted a renewal application and you're sitting here 3-4 days later and you haven't heard anything, a week later, you haven't heard anything, it's been a week. You want to follow up with us and check why. Maybe there's something wrong. Maybe there's something missing. We tried to reach out, or maybe we sent that email. And like I said, maybe your email blocked it. Maybe it's in your spam folder. You just haven't seen it. Be proactive, just like on a new application. Be proactive and check if you haven't heard anything, especially for renewals. The turnaround on renewal applications is not more than a couple of days usually. Get sworn in within 30 days. So emphasize it a lot already on this page here. Same thing, right? Get sworn in. Same thing, $11 to get sworn in at the clerk of the court, different than the application fee. If you if you fail to get sworn in within 30 days, that commission gets revoked and you have to reapply as a new notary. Nobody wants to do that. We don't want you to do that. The law requires that to be the case, so please don't make us do that. We don't like to do it either, but it is the law. It's the way the law is written. So help us help you. Make sure you follow up and be proactive if you haven't heard anything, and make sure you get to the clerk of the court within 30 days to get sworn in. Changing name and address. Go online, same place you apply. Click to update your notary information. You can update your name. If you want to get sworn in under a new name, you have to pay a $5 fee. We'll reissue a commission. And just like if you were a renewal, if you get sworn in under your new name, you have to go to the clerk of the court, get sworn in, take the oath of office under the new name, get your new commission, and you finish out your term under your new name. You don't have to get a new commission and finish your term under your new name. If your commission is a notary and you just want to finish out your term under your current name, you can do that. And when it comes time to renew, that's when you'll get sworn in under your new name. So you could choose to finish your term out under your current name, or when you notify us of your name change, you can notify us that you want to get a new commission and finish out your term under your new name. Either one is acceptable. Changing your address, same link. You're going to see this link a lot in our handbook, online, and in this presentation. If you look it over again, this is the same link. Go there. Update your information. It's important to update your information. Keep your address current. Keep your work address current. Keep your home and work phone numbers current. Keep your info current. And we're required to have that certain contact information, name, address, home phone, cell phone, if one was provided, email address, business phone number, county of residence. One important little point I want to make here, if you change addresses, and say I'm in Anne Arundel County now, say I move to Baltimore City, I don't change my seal. I don't change that information. I update my address on file with the Secretary of State. And when you change your address, you're finishing out your term in whatever county it was you were sworn in. Even if you move to a new county during that term, you're still going to finish out in the county in which you were sworn in. And when you renew, that's when you'll go to the new county and get sworn in there and become a notary for that particular new jurisdiction. Enforcement, let's hope it never has to happen for anybody, right? But we may deny, refuse to renew, revoke, suspend, or impose conditions on a notary commission for an act or omission demonstrating a lack of honesty, integrity, competence, or reliability. There were several items listed here that could cause that to happen. Most frequently, it's bad information on a notary application, or a notary doing something as a notary that they weren't supposed to do. Maybe they knew they shouldn't do it and did it anyway. Maybe they didn't know they shouldn't have done it and did it. Either way, and there'll be a town hall about common mistakes that notaries make. We'll have a whole town hall on this type of stuff that notaries do. That'll provide a little more detailed information about different things that notaries do that are wrong and how to avoid doing those. Long list here, though, and all this is right out of the handbook. Hearings, if a notary were to do something wrong and we were to decide that we were going to look to remove the notary or revoke their commission, There's a hearing process that plays out. We provide an opportunity to the notary to have a hearing. It's an informal hearing. It is not, you're not going to court. It's nothing like that. You're not going before a judge. It's an agency, hearing here where, but not a contested case hearing in that sense of an agency hearing. It's a hearing where we're going to give you an opportunity to explain yourself and explain why we shouldn't remove you from office of notary public. And then we'll make a decision after that informal hearing regarding whether or not you should stay a notary or you should be removed from office. They're not fun. We don't want to have these, just like everybody else doesn't want to be in one. And most important thing is to know the law and follow that law. And like I said, this handbook that we're doing an overview on is the best place to learn and know the law and the regs. A notary convicted of a felony or other crime. If the notary is convicted of a felony or crime involving fraud, dishonesty, or deceit, they have to report that conviction within 10 days of that conviction or within 10 days after they're released from incarceration, whichever is later. So if you're a notary and you get convicted of a crime, let us know if it fits this category, felony or a crime involving fraud, dishonesty, or deceit. Must notify us within 10 days. If you go to jail after that conviction, you get till 10 days after release to notify us. Failure to notify us would result in an enforcement action. A couple other things. I mentioned another reason notaries end up getting in trouble notarizing something incorrectly. Even if we were to decide you notarize something incorrectly and take some type of action regarding your commission, the failure of the notary to perform their duties correctly does not necessarily invalidate the notarial act or the document that was notarized. And regardless of what we decide to do to a notary's commission, it doesn't mean an aggrieved person cannot seek to invalidate that record or find other remedies that are allowed under federal or state law. So regardless of what we decide, you could still take action privately regarding an incorrectly notarized act. And regardless of what happens, in any private litigation or matter, our office could decide to or not to remove a notary public if we decide whichever one we decide is appropriate. So powers, authority, and jurisdiction, conflict of interest, and other restrictions. It's a lot of information here. There's some general powers of a notary public. Take an acknowledgement, oath or affirmation, witness or attest a signature, certified copy, certify a tangible copy of electronic record, make a protest. That last one is rarely seen, at least not in a form that's acceptable under the law. Most of the time, you're going to be doing an acknowledgement, oath or affirmation, witness or attest a signature, and to a lesser degree, the certified copies requests. When and where can you do this? So we talked about earlier some of this information. If you're a Maryland notary, regardless of where you get your commission, you can notarize anywhere within the state of Maryland. You cannot, however, take your Maryland notary seal and notarize outside the state of Maryland. So if you're standing in DC or Virginia or Delaware or wherever, you cannot act as a Maryland notary. You don't have the authority to act as a Maryland notary in that state. You're commissioned to act in Maryland and only Maryland. That's where your authority to be a notary is, and that's where you can act as a notary. The only reason you could be a notary in another state is, like we talked about earlier, if you're commissioned in that state as well. So if you hold a notary license or commission in Maryland and let's say DC, when you're in DC, you use your DC commission. When you're in Maryland, you use your Maryland commission. Must be physically present in the state to act. And the same thing is true, the opposite of what we just said. If you're commissioned as a notary in another state, you don't have the authority to come to Maryland and notarize unless you're also a Maryland notary, in which case you'd be notarizing as a Maryland notary. Doesn't matter. Don't confuse this with where the document is coming from or going to. That's not relevant. What matters is where you are standing at the time you notarize a document for someone. So that document could be from California or going to California, from somewhere across the world. It doesn't matter. It could be going to the moon or from the moon for all that matters. If you're a Maryland notary, you just have to be here when you're notarizing it. Doesn't matter where it came from or where it's going to. Some conflicts of interest, restrictions to be aware of. A notarial officer, a notary public is right there, an independent party to witness these signatures on this document. So if you're not an independent third party, it's probably a good idea to stay out of it. One definite no is you cannot notarize for yourself and you cannot notarize for your spouse. So I cannot notarize my own signature.
Mike, I think you're muted.
Wow, not sure how I got muted there.
Okay, you're back. Thanks.
Thanks to anybody that did that. So you cannot notarize for yourself or your spouse. That is not allowed by law. You cannot notarize for yourself or your spouse. You cannot notarize for anything you or your spouse have a direct beneficial interest in. Now, those are the two express parties for which you cannot notarize that are mentioned in the law. But what I'll tell you, just as somebody that has received notary complaints over the years, even though you do not have to refrain for somebody that is not yourself or your spouse, it's best to stay away from and refrain from notarizing for members of your immediate family. Even though you're not necessarily under a legal duty to refrain from notarizing for a member of your family, it is best to not do that. There are 80-some to 90,000 notaries in the state of Maryland. Trust me, there are plenty out there. Go find a notary that you are not related to and have them notarize it for you. While you may ask their family, everything's always great in family. We all know that that doesn't always end up being the case. And, there are situations, where you just don't want to be involved in, or you don't want to put yourself out there to get involved in. People notarize for family members and it's great today, and 3 years later that relationship may not be as great anymore, and that's where problems come into play. Whether you did anything wrong or not, sometimes those disputes get messy and ugly, and it's best to avoid those. We talk about being an independent witness. Even though the law doesn't say you can't notarize for folks outside of yourself and your spouse, it's best to stay away from notarizing for your family members. Why do I spend so much time on it? I just want to drill that point in, that it's best to stay away. If you're thinking about it, do yourself a favor and don't. No matter how good you think everything is, you never know how it turns out years later.
And Mike, isn't it right that many of the complaints that you've investigated or that have been investigated over the years have been complaints about family members who have notarized a document for another family member?
Oh yeah. In a prior life here, I reviewed notary complaints and looked into them, and I can tell you a very solid chunk of those, maybe even half or more than half, involved a dispute between family members. And out of those, I can't tell you how many times, but a lot of the time they had yet another family member that notarized it. And it's not a good situation. Don't put yourself in it. And I'll say this for this, but I'll say this just in general: refrain, no matter what pressure, even like, so you don't have to, that's true, but you should. And if your family member is leaning on you to do it, come on, we're family, we're buddies, we're great, we're friends. If they care, if they truly care, they'll understand why you don't want to and why you refrain, and that you feel that it's a good obligation to do that and a good practice to do that. Just like if anybody ever asks you to do a favor for them where you shouldn't be doing what you're doing, and they're asking you to do it anyway, if they're really your friend, they'll understand why you can't do it and that you shouldn't do it and that you're acting in accordance with the law. And for family, like I said, you're only under a legal duty to refrain from notarizing for yourself and your spouse. But do yourself a favor, don't notarize for your immediate family. Notary public may perform a notarial act for any person to any instrument which involves corporation of which the notary is an employee and to which the notary public is not a party. People always say, well, I work for my company and I notarize stuff at work. Perfectly fine. Perfectly fine. That's one of the main reasons your company probably has you be a notary. It's way easier to have a notary on staff notarizing company documents than it is to try to find somebody else to notarize a bunch of stuff for your company. So there is that exception that is allowed. That seems like a conflict, but in reality, you're notarizing stuff. Just you follow the law, right? You're still a notary, still got to follow the law, but you can notarize documentation for stuff that involves your employer and the people you work with, unless it's your spouse. Other restrictions: notary commission does not authorize an individual to do certain things. I'm a notary public. I cannot assist people in drafting legal records, give legal advice, or otherwise practice law. In order to do that, I have to be an attorney, not just a notary. And a notary is not an attorney. No matter what some people may like to think of it, they are not an attorney. They cannot draft legal records or give advice or practice law unless they are licensed as an attorney. Cannot say, I'm a notary, let me help you with your immigration paperwork, unless you are specialized in that field and allowed to do that. A notary public does not make you an immigration expert. Represent someone in a judicial or administrative proceeding, similar to relating to immigration to the U.S. citizenship, or related matters. Again, just because you're a notary doesn't mean you're an expert in that field. There are other things that make you an expert in that field. You have to qualify for that stuff, whatever all that is exactly, in order to be an expert in that field. Being a notary in and of itself does not make you one. And you can't receive compensation for performing any of the above acts if you're a notary public. And if you're an attorney, obviously you can receive compensation to practice law and be an attorney. But if you're just a notary public and you're trying to perform the above stuff, you can't do it as a notary public unless you're licensed in those areas or credentialed in those areas. And you certainly can't be compensated to do it unless you are licensed or credentialed in those areas. Notary public may not also engage with false or deceptive advertising, cannot use the name notario or notario publico unless the notary is licensed to practice law in Maryland. And you cannot advertise or represent that you can do those above things that we said you cannot do unless you're licensed to practice law. And if you are licensed to practice, a notary who is not licensed to practice law in Maryland, if they advertise their notarial services, they need to have a statement that says what it says at the bottom of the page. I am not an attorney licensed to practice law in the state. I'm not allowed to draft legal records, give advice on legal matters, including immigration, or charge a fee for those activities. So if you're advertising your services, this statement needs to be accompanying that advertisement somewhere with that advertisement. Identifying a person appearing before a notary, competence, these kind of wrap one into the other together. Appearing before a notary, still required to appear before a notary public. Still has to happen, always has to happen, whether it's the appearing in person or the appearing using authorized remote notary technology, which is very specific technology that's approved by us, and the list of approved remote notary technologies is on our website. When we talk about remotes, we're not talking about Skype and FaceTime and stuff. We're talking about remote notary technology that's purpose designed, that has extra security enhancements in there that can help prevent fraud and make sure the person is who they say they are and is appearing before them remotely, and allowing the notary to witness the signature of the document, perform their acts contemporaneously with the person being identified and signing it. So a notary must require the person to personally appear before them, like I said, in person or remotely. This means, in the traditional sense, that means we're standing together in person in the same place at the same time. I see you, you see me, I identify you, I watch you sign the document, I notarize the document, oath acknowledgement, whichever it is, or official witness or something else. We're all together. We're together at the time of the notarial act. I need to identify the person for whom I'm notarizing. Every time, have to identify the person. Every act, every time, every. What are methods of identifying a signer? Somebody who needs a notarial act done for them. Personal knowledge is one. What's personal knowledge? I have personal knowledge of the identity of the person appearing before me, and it's sufficient to provide certainty of identity. When I say personal knowledge, I mean I know the person, I know them, not I've seen them in passing, or I remotely know them because they come into my business every now and then. I know them. I know that person. I have personal knowledge of them. Government issued identification. This is the best method that you can use for anybody, including some folks you know. Satisfactory evidence of identity using government issued identification. What does that mean? Government issued identification for the purpose of identifying somebody you're going to notarize for. Passport, driver's license, consular identification, other government issued non-driver ID cards. Folks in Maryland, if they don't have a driver's license, they can still get a government issued non-driver identification card from the MVA. Need to have a government issued photo ID, and that government issued photo ID needs to contain a signature and a photo of the individual, and it has to be satisfactory to the notary. So why is a passport or a driver's license or other government issued ID, non-driver government issued ID valid? Because it contains the signature of the person and their photo. You can look at that picture and go, yep, that's the person, that's them. They're the one signing before me, and it contains their signature as well. Another method that's allowed is something called a credible witness. You can identify someone using a credible witness. And what does that mean? That means maybe somebody doesn't have an identification, and somebody else that you know, or maybe somebody that you don't know, identifies that person to be the person that needs the notarial act done. What happens in that situation? You're going to identify that credible witness, and you're going to get their information. You're going to record it in your journal, and they're going to attest or swear to the fact that the person is who they say they are. You're going to identify that third-party witness. Like I said, you're going to get that information. This is not ideal. There are times when this is appropriate. Maybe it's somebody that doesn't have a driver's license yet, like a minor. Maybe that minor doesn't have a passport. I didn't have one when I was a minor, right? So I would have needed a credible third-party witness to identify me if I was going to have something signed and notarized before I had my driver's license. So maybe another situation, maybe somebody that's more on the elderly side that doesn't drive anymore and doesn't have a valid government issued ID. Although, the reality is that expired old valid government issued ID will still satisfy, right? Doesn't have to be a current driver's license. It has to be a government issued ID. But if it's expired, you could still use it. But the point being, credible witness, there's limited applicability there, right? You don't want to use credible witness for everybody. If I'm coming to you, I drive to you to get a document notarized, and I say, whoops, I don't have a driver's license. I mean, I have bigger problems on my hand, like driving without a license, right? So there's really the credible witness thing. It's applicable in certain situations, but government issued photo ID is the best one. Personal knowledge is also a good one. Credible witness is allowed, but again, limited applicability. Competency and awareness. Unless otherwise prohibited by law, a notary may refuse to perform a notarial act if they're not satisfied the individual executing the record is competent or has the capacity to execute the record. How do you gauge competency awareness? You ever meet somebody and know they may not quite know what's going on? And that's really how this kind of works as being a notary, right? You're going to interact directly with the person requesting the notarial act. If Assistant Secretary Smith and I come to get a notarial act done, and I'm the one doing all the yammering, but she's the one that has to sign the document and get it notarized, right? There's a problem there. The notary would want to interact directly with the person for whom they're going to notarize. Well, I'm not getting the document notarized for me. She's getting it notarized for her. That's the person you should be talking to, and you're going to interact directly with them. It's, we're not asking you to be a doctor. You're not giving them a written exam or anything like that. You're going to directly interact with that person and use your judgment to determine competency and awareness. Other item to look for is duress. A notary may refuse a notarial act if they're not satisfied that the signer's signature is being applied knowingly and voluntary. If the notary determines a signer is under duress, the notary should refuse to notarize that document. The example I just gave, Mrs. Smith and I are going somewhere and I'm being pushy and she seems reluctant and doesn't really want to do it, and I'm not letting you interact with her, and I'm the one driving everything, and I'm refusing to cooperate and allow her to do it. That's a good sign of a lack of competency and awareness, or maybe there's duress there, and it's okay to refuse that notarial act if you detect duress. Perfectly acceptable. And you should do it. Now the law tells you you should do it if you detect duress. Physically unable to sign. If a person's not impaired or under duress, but they cannot sign, they could have somebody appear with them before you, the notary. So you have the person that would sign, somebody with them, and yourself, the notary, all together, present with each other. And that person who's physically unable to sign is allowed to direct that other individual to sign their name to the document. And as a notary, you're going to want to get that other person's contact info. You're going to want to view their ID and enter their information in your register as part of that transaction. And the notary would want to definitely note that in their journal. And the notary will want to also insert some wording on the record that indicates that the signature was affixed by whoever it was that signed the name at the direction of the person that couldn't sign it. Important to note that if it ever comes back later and it's not noted, who's to say whether it did or didn't happen? So if you ever run into this situation, make sure it's noted on the document by you as the notary. Make sure you have an entry in your journal about this happening. Have to enter everything in your journal anyway. So you want to make the extra notes to account for this situation. Doesn't happen often, but happens every now and then. Notary's official stamp. We talked about this at length as well in the applying and renewing town hall. Notary's official stamp. Everybody used to know it as their notary seal. It's now called a stamping device. And it could be an ink stamp. It could be an embosser. Either one is acceptable. The official stamp has to include your name as it appears on your notary commission. I'm Michael Schlein. My stamp needs to say Michael Schlein because my commission would say Michael Schlein. If my commission says M. Schlein, that's what my stamp should say. It needs to, your stamp / seal needs to match the name as it appears on your notary commission. So when you apply, make sure it's got the name you want on there. There's even a field when you're filling out the application, as you type in your name, it shows you how your name will appear on your notary commission. If you don't like it, change it. Make sure it's the way you want it. But it also has to be your legal name. I can't use a nickname. I can't be Mike or Mikey Schlein. It's got to be Michael Schlein. It's my legal name is Michael. It's got to be Michael. But I could choose a middle name, no middle name, middle initial, things of that nature. It's got to be my legal name. So name, the words Notary Public, and the county in which the notary is commissioned, or if it's Baltimore City, City of Baltimore, would appear on your notary seal. For most folks that live in Maryland, that are notaries that live in Maryland, it's going to be the county in which you reside at the time you get commissioned. For folks that do not live in Maryland but are Maryland notaries because they work here, it's going to be the county in which you're commissioned. The expiration date is only required on your notary seal if it's not a part of the notarial certificate that is on the document that you're notarizing. So one of the big changes that happened on October 1st, 2020 is now every notarial act that you perform, you're required to complete a certificate. And if there's not already a notarial certificate on the record that you're notarizing, you have to attach one. And there are sample certificates in the handbook that are pulled directly from a wall that you can use to affix to a notarial act. And every one of those certificates has a place where you can write your expiration date. So the reality is, as much as an expiration date might be required on your seal, it's only required if it's not a part of the certificate. And if you're a notary and you're making sure the certificate's attached, or attaching it if there's not one already there, that good certificate should already have your expiration date or a place for you to write it, and therefore it wouldn't be needed on your notary seal. Other important thing about being a notary and having your notary seal, it is yours. That notary stamping device, notary seal, it is yours. It is your individual property. It has your name on it. Doesn't matter who bought it. Maybe you became a notary because of where you work. They paid for your application and your notary seal. Great, thank you very much. It's still your notary seal. If you were to leave there, you take it with you. It's your property. It has your name on it. You, like we talked about earlier, you are an officer of the state. Individually, you are the officer of the state, no one else. So it's your seal. Take it with you at all times.
Mike, this is a really good point to emphasize and re-emphasize and emphasize again for exactly the reasons you just said. You know, we talked a short while ago about the importance of commissioning and going in person. The actual person who took the exam, who submitted the application and, you know, took the course of study, they're the ones who need to go and be commissioned. It's your commission. This is a public office. And so I know it gets a little muddy sometimes when an employer purchases the equipment for a notary, and it can feel like a little bit of a tussle. But in fact, as you said, it is the notary's personal possession that has to go with the notary. And if you, we'll talk in a few minutes about if you resign the notarization, your notary commission, the importance of disabling that stamp. So I know we'll get to that in a few minutes, but that is why it's so critical, because it is attached specifically to the person who was commissioned as a notary public.
Yep. And so if when the time comes that you're no longer a notary public, whether that's because you expire or you resign partway through, or hopefully not revoked, but whatever the reason is, you want to disable your stamping device, you want to render it unusable. If it's a rubber ink stamp, it's pretty easy to render it unusable, right? Just take the rubber stamper part off and, cut it up and can't be used. The embossers are a little harder to render unusable. You really need to disassemble them. But you want to make them unusable. You don't want to let somebody else just take it and have it. We've heard plenty of terrible stories, over time where the notary left their employer and they weren't even made to leave their seal. They just said, well, I'm not going to be a notary anymore. They left their stuff at their employer, and that seal started showing up on documents. And what happened, is their name and signature were on it, even though they didn't sign it. And, we get a complaint, who are people complaining about, right? They're complaining about the notary because that's the name that appears. And, we end up contacting the notary, and they're kind of terrified to hear what's been going on. And, they just weren't thinking, what can happen. You may have even left on good terms. But it doesn't mean somebody's not going to take that seal and maybe try to use it. It's your seal. Take it with you if you leave, and make sure it's in your possession. Keep it safely. And if you lose it, notify us. Notify us as soon as possible. Notary record keeping. So journal. In the old law, it used to be called a Fair Register of Official Acts. The law that went into effect October 1st, 2020 now calls it a journal. So if you ever hear somebody use the term journaling with regards to a notary, this is what they're talking about. Every notarial act you perform, you have to make an entry in your journal. Each and every notarial act. But Mike, I notarize for the same person every day. Great, you'll have a notary, an entry in your journal for that same person every day. The law is the law. It requires it for each and every notarial act, a journal entry to be made. You need to retain that journal for 10 years after the performance of the last notarial act in that journal. Could be paper book, could be electronic. If you're doing the traditional notarial acts, paper book probably makes sense, right? And if you're using they call it a tangible record, if your journal is tangible, in other words, a book or paper, it must be permanent and bound with numbered pages. Can't just attach loose leaf sheets of paper together anymore and call it a journal. You have to have a book. The pages have to be bound. They have to be numbered. Make your own book, great. Buy a book, great. Either way, it has to be bound. It has to have numbered pages. You can have an electronic journal as well. In that case, it must be permanent and tamper evident and comply with the requirements in the law regarding those electronic records. Each journal, what does it have to maintain? So you remember the old law, didn't really say much. It said you had to keep a journal. Our handbook explained items you should keep. Well, now the law, it clearly explains what is required for each and every notarial act for your journal entry. This seems like a lot of information. I can't tell you how many times people that did this were saved by the fact that they had good detailed information in their journal. It's required by law to keep it. Why is it required by law? You're an officer of the state. You have to have a record of your actions. But also, it's good to have that record because you never know what's going to come back a few years down the road. Maybe something like, we talked about family disputes earlier that seemed totally fine at the time comes back. And if you have your journal, it's going to be very easy to show that you identify them, watched them sign, and you did the right thing as a notary public for that notarial act. What's in that journal? Date and time of the act, description of the record and type of notarial act, name and address of the individual who appeared before you to get it signed, how you identify them. Was it personal knowledge or was it based on satisfactory evidence using an identification credential? Did you look at their driver's license? If you did, if you use that ID card like a passport or license, you're going to write down the issue and expiration of that ID and the ID number associated with it. So if you have a driver's license, everybody knows there's a driver's license number on your license. And I'm not asking, don't everybody respond, but just asking kind of just for everybody to think about, how many people actually know their full driver's license number? Yeah, I mean, I know what mine starts with, right? It's always the first letter of your last name. But beyond that, I can get about 6 numbers deep. Most people don't know the full 12 numbers that come after that letter. But if you have it in your journal, well, it's really hard to say you didn't identify them and you didn't watch them sign a document and notarize it properly, right? So you have to keep the stuff in your journal. It's required by law, but just an example there of why, not just it's that you're an officer of the state and you have to keep a record of your actions, but that record comes in handy should anything ever be called into question. What else? You need to have the fee. If you charge the fee, if you didn't charge a fee, indicate you didn't charge a fee. We're going to talk about fees here in a little bit and indicate the statement or that the signature, the subject of the act, if they appeared in person or remotely, if you're approved to do, if you're authorized to do remote notarial acts, this one's of vital importance because you need to signify whether or not you did one remotely or in person. And if that journal is lost or stolen, tell us. It's your property as well, just like the seal. It is your record. This is your record of everything you've done. It is yours. You can engage with a third party to keep it as a repository for you. This is mostly applicable for remote notarial acts in the sense that your remote notary service provider, your approved technology that you use, if you're approved to do remote notarial acts, they likely have a journal on their platform that journals all the notarial acts that you've done using their platform. And you can keep it on there and you don't have to keep it yourself separately. It can be used on that platform and that's perfectly acceptable. If you were to resign or be revoked or suspended or just decide you wanted to expire, you still have to keep that journal for the 10 years. Notarial certificates. So we talked about notarial certificates briefly earlier. Each and every notarial act now requires a certificate to be on that record that was notarized. If you get a document that comes to you and somebody asking you to notarize it for them and there is not a notarial certificate on that document, you must now affix one and then complete that certificate to indicate that you perform the notarial act. If there's no notarial certificate, there's no notarial act. It's not performed. Each act requires that certificate. It needs to be evidenced by the completion of a notarial certificate that is attached to that record. Whether it's on the record pre-printed or attached and filled out, either is acceptable. What do you attach? What certificate? Well, it depends on what the person's asking you for, right? If they just want you to notarize their signature, you got witness and attest. If they need to do an oath or affirmation, you can attach the oath or affirmation certificate or acknowledgement, the same. It's based upon what they're asking of you as the notary to notarize for them. Each notarial act shall be evidenced by a certificate. It shall be executed contemporaneously with the performance of the notarial act. What does that mean? That means you bring me a document and I notarize it. We're doing it at the same time. I'm filling out that certificate. I am notarizing it at the same time that you're signing it, and I'm identifying you and I'm making the journal entry. I complete that notarial act at the same time. I don't put it down and come back to it weeks later, days later, hours later. Everything needs to happen in the same occurrence. That notarial certificate needs to be signed and dated by the notary. Needs to have their office. So, generally speaking, it's notary public. And you want to sign in the same manner in which you signed at the clerk of the court. When you go take your oath of office and get your commission, you sign a book. You want to sign that book the same way you sign generally so that you can sign that way when you notarize. That certificate needs to identify the jurisdiction in which the notarial act is performed. So when you're filling out a certificate, if you look at the samples, you'll see every one of them is State of Maryland, County of blank, or City of Baltimore. It's always State of Maryland if you're a Maryland notary. Why? Because you're doing it in the state of Maryland. You can't notarize outside of Maryland with your Maryland notary seal. So your certificate should always start with State of Maryland. And then the county in which you're performing the act is the county you're going to note. So if I'm standing in Anne Arundel County, it's State of Maryland, County of Anne Arundel. If I'm on vacation down at the beach and I go down to Ocean City, I'm in Worcester County. If I notarize, it's going to be State of Maryland, County of Worcester. If I'm out in Oakland, Maryland, State of Maryland, County of Garrett. It is indicating where you were at the time you notarized that document. This certificate is giving the details of what is true when you notarize it. Who came before you? What did they do? Did they take an oath, an acknowledgement, or did they just witness their signature, or did they attest to the signature? Or was it a certified copy? Where did it occur? On what day did it occur? Those are all the elements of that certificate that are vitally important for you to complete, and then you sign a fixture notary seal. The notary certificate says where it happened. Your notary seal says where you're commissioned. A few more things about notarial certificates. When you attach that certificate, you're indicating you comply with these certain aspects of the law. They have to do with identifying the signer, competency and duress, things of that nature. If the notarial act regarding the tangible record is performed, the notary shall affix their stamp or embosser to the certificate. Ideally, right, the certificate's pre-printed on the document. It's not always, so you have to attach it securely. What does that mean? It means attach it securely. Whether you staple it, clip it, stamp it, however it is, you attach it securely, that certificate to the document. And an electronic record, it has to be affixed so that it's logically associated with it. And that becomes more evident for folks, especially that are doing remote notarial acts. You'll learn about that and how that works. If you have a technology that you use for remote notarial acts, they teach you how to do that when you try to sign up and use their platform. A few other things here. What you'll notice, people ask us sometimes, does the certificate have to say exactly what it says in the law? No, it should look something like that. So it can be in a short form provided in 8-216. That's the section of law where it gives examples of all the certificates. Another form allowed by the law, or in a form allowable in the jurisdiction in which the notarial act was performed. Basically, it should look something like that certificate in the law. Maybe there's some extra wording based on the situation, and that's perfectly fine. But it needs to be an oath or affirmation or an acknowledgement or a witness or test or certified. It has to be one of the types of notarial acts a notary can perform. There are different types of notarial acts. We went over them briefly earlier. Acknowledgement, oath affirmation, witness or test, certified copy, copy of an electronic record, protest. Regardless of the type of notarial act, there are certain things you need to do. And the handbook breaks down each one individually into different steps on how to perform those notarial acts. If you've never looked at it, do yourself a favor, look at it. It's good information. It tells you how to do it. But regardless of the type of notarial act, you're always going to have to identify your signer, right? They have to appear before you personally, and you have to identify them each and every time. You always have to record that act in your journal. You always have to attach apply your stamping device, your notary seal, and you always have to complete the notarial certificate. These 5 items are done no matter what type of notarial act you're doing, no matter what. But specifically for each type of notarial act, it breaks it down in a lot more detail. We're not going to get into every detail here. There is a future town hall that does that, where it breaks down each type of notarial act, and we're going to go over each one in some more detail. Electronic notarizations, what is this? It's not remote notarial acts. You see electronic kind of scattered throughout. You could have an electronic notarization that's not a remote notarial act. An electronic notarization is really just a electronic version of your traditional in-person notarial act. Physical presence still required. I still have to be in the same place as the notary. The signer and the notary have to be together. Still have to identify the signer. The difference between a traditional notarization and an electronic one is that it's not a wet ink signature. It's an electronic signature attached electronically to an electronic record that the notary will notarize electronically as well. But that all happens in person together. I would basically watch you sign the electronic record in person for an electronic notarization. And you could put it in a traditional journal, or you could put it in your electronic journal. Either way. But electronic notarizations do have to meet certain standards in the law with regards to the digital certificate requirements. Their notary seal and signature need to meet these standards. And if your digital certificate's expired, revoked, terminated, invalid, or incapable, can't use it. Remote notarizations. This is what everybody thinks about when they think of electronic, but it is a different thing. Remote notarial acts, you can perform using approved remote notary technology. We have a list of authorized remote notary vendors, or we call them RON vendors, remote online notarization vendors. It's found on our website. If you go to the Secretary of State's page, you click on the notary page, scroll down just a little bit, and the list of approved RON vendors is there. You have to use one of them if you're performing remote notarial acts. This is not video conferencing, right? Notarial acts, remote notarial acts, it's not, they're allowed under the law, but they're allowed under the law using the approved technology. They're not allowed under the law if you're using Skype or Teams or Google Meet or FaceTime or whatever. They do not meet the requirements of the remote notary technology in the state of Maryland. Have to use the approved vendors. Remote notarial acts cannot be performed for a will or a trust instrument. All other forms of documentation can be notarized remotely. And if the notary performs a remote notarial act for a power of attorney, the notary cannot also serve as one of the additional witnesses for that power of attorney. People will often ask us, can I, if the document needs a notarization for the signer and somebody else has to write as a witness, can I do both? Sure, unless you're remotely notarizing a power of attorney, in which case you can't do both. Validity of a remote notarial act performed by a Maryland notary shall be determined under the laws of Maryland, regardless of the location of the remotely located individual. What does that mean? If I'm a remote notary in Maryland and I'm notarizing, I have to be in the state of Maryland when I'm notarizing, right? I only have authority to act as a notary when I'm physically standing in the state of Maryland, whether it's a traditional or remote notarial act. The signer, however, for a remote notarial act, the signer could be anywhere. So they could be in another state, could be on another planet. As long as you're using the approved technology, and the notary is physically located in Maryland at the time of the remote notarial act, that signer could be anywhere around the world. The notary shall notify a Secretary of State that they intend to perform remote notarial acts. Again, that just like the list of RON vendors on the notary page of the Secretary of State website, there's a form you can pull and complete and send to us so that you can get authorized to perform remote notarial acts using one or more of the approved technologies.
And Mike, that's a really good point to really make again and again and again. I think that just because there's an intention to perform a remote notarial act, the notaries aren't automatically authorized to do so. You must notify our office to do so and go through that process. So, and there's a whole session in November that will be held on remote notarizations. But just because you want to be a remote notary doesn't mean you can automatically be one. You've got to follow the process that Mike identified.
Right. One other important point to make is that your authority to perform remote notarial acts expires with your notary commission, which means that when you renew, you need to send us an updated remote notary notification form telling us you're going to remotely notarize again under your new commission. Right? If you're not a notary anymore, you can't notarize remotely. So when your current commission expires and you get another one, you need to notify us again. Hey, Mike, notary again, and I'm going to keep doing remote notarial acts. So notification for every commission. Charges and fees. Notary public may not demand more than $4 for the performance of a notarial act. Whether that's a regular notarial act or a remote notarial act, $4 per notarial act. What does that mean? That's essentially $4 per signature, right? If I notarize for one person, it's $4, two people, 8, 3, 12, and so on. In addition to the $4 for the performance of an original notarial act, a notary, if they travel, may demand and receive reimbursement at the IRS rate for business travel and a fee not to exceed $5 for travel. And it's important there, the and. It's not just a cap of $5. If I travel to notarize, I can charge $5 because I'm traveling, plus mileage, round trip mileage, plus $4 per notarial act. So if you're traveling, you can do all of those together, right? You add up $5 plus mileage plus notarial act fees. And that's what you can charge to travel. Important point to make here, if you're traveling, when you put that fee you charge in your journal, probably a good idea to break that down, right? Why? Because if your journal says you charge somebody $40 for a notarial act, it looks kind of bad, right? And you're already going to have to do the math. When you calculate how much you charge, you're already going to have to go, okay, $5 plus, I don't know, 50 miles at X dollars per mile, plus $4 per notarial act. Just make a little breakdown of that fee so that it's obvious what the fee was for, and it doesn't look like you're charging all that money for a notarial act.
Boy, Mike, that's such an important point to make. I know that you've had several complaints, many complaints over the years about notaries who have overcharged, because the allowable fee right now, as you said, is $4 for each act. We've had folks who have charged lots of money, way in excess of that. And so breaking down what that fee is that's being charged for each specific category really will help prevent any confusion and protect all of our notaries from any claims of overcharging.
Yeah, exactly. We've seen some pretty outrageous fees over the years. And we've had some folks that recorded in their journal, and when we talk to them, they explain, well, I traveled and here's what it was, but they don't remember where it was anymore. They just remember they traveled, and they can't give a breakdown to verify that it was the right amount charged or that they didn't overcharge. Just give a breakdown on that if you're traveling for notarial acts. Make life easier on you should there ever be a question. And some people just, quite frankly, they see $4 and they think, oh, I paid all this person all this money, not even thinking about the fact that they're allowed to charge for travel. Right. So, they may file a complaint with us and not even realize that you were justified in charging them the travel rates, the $5 fee, and the $4 per act. And, it's easy to clear that up very quickly if you have the fee in your journal like you're required to. But if you do the math for yourself in that journal as well, it makes life a lot easier later.
And the Internal Revenue Service adjusts the amount of money that can be charged per fee. So we always refer you to the IRS for what the established mileage is that they're authorizing.
Right. The couple other fees I'm not going to spend too much time on. We don't see these that often. Those first two items are the two big ones that you really want to remember out of all this. But if I am being asked to notarize the exact same document multiple times, be $4 for each original notarial act, and then $1 for each act on subsequent copies of that same exact document. Notary may demand and receive not more than $1 for each photocopy made. So I notarize something, and the person wants a copy of the notarial act. Make a copy, charge them $1. A notary public may charge $2 for certifying a copy of a record in their journal. So if somebody asks for a copy of the journal, you can charge them $2 and make a copy of the entry. Although if you identified somebody using an identification credential, where you're going to have their driver's license number and personal information in there, their PII or personal identifying information, you don't want to share that personal information with somebody from the public. Public information. Nice unintentional segue there. So public information, what we're referring to here is what is public information about the notary. The name of the notary is public information. Their business address and business phone number are public information. Their issue and expiration dates, date they took the oath of office, their signature are all public information. Applications with us, they're all online now anyway. So the only real signature record that you're going to find on a notary is the one that they sign at the book when the notary gets sworn in at the clerk of the court for each commission. Important points to note here. We don't have your business address. Your home address is the address of record. If we don't have a business phone number, your home phone number is the address of record. If you don't
Mike, I think you froze there.
phone number for you.
You're back again.
Oh.
Okay.
Am I back? There you go. If we don't have that business address and phone number information on hand, if it's no longer current, if you've moved employers or phone numbers or whatnot, and you don't keep it up to date, information out there, make sure you're keeping your work information current with us as well. We may publish information relating to the status of a notary, when their commission was issued or expired, and maybe they're no longer a notary because they expired or they were suspended or they chose not to renew or it was revoked. We don't put the details behind all that, but we're allowed to explain what it was or say what it was that why you're no longer a notary. The most often reason is because somebody expired and chose not to renew. We couldn't share the details, though. If somebody did have a commission revoked, the details of that are not public information, just the fact that it was revoked. We may also allow inspection of other information about a notary if we as the custodian find a compelling public purpose. A person would have to provide an explanation that is a compelling public purpose to get any other information about a notary that's not listed above. And that would be a determination that we would make as the Secretary of State, as the custodian of that notary information. So there are some upcoming town halls, May 23rd, September 26th, November 21st. Again, breaking down some of this information we talked about in greater detail, types of notarizations, how to avoid complaints, remote notarizations are going to get talked about in much more detail in those sessions. They'll also run about an hour. Every now and like this one's a little longer, just so much information on this and this particular topic. But with that, Mrs. Smith, I'm going to turn it back to you.
Thanks so much, Mike. There's a lot of information here to share. We have questions that I know have been popping up in the chat box, so we will get to them. We only have a few minutes left, so we'll get to as many as we can. But before I do, first let me thank you, Mike. You did an outstanding job as always. I'm so grateful. Thank you, Deputy Secretary Barunda, for also joining us earlier today. As we shared earlier, you know, today's every town hall has been recorded. It will be uploaded on our website, the Secretary of State's website, under the Notary tab, and the PowerPoint for today will also be provided on, pardon me, under the same Notary tab. Also stated earlier, the content and presentation provided is for informational purposes only. It is not intended to be legal advice. Mike showed the display of the upcoming town halls. If you have a question or comment about a recommendation for a future topic that is within the scope of the notarying law and regulations and handbook, we will be happy to consider it if we have capacity. There were a few questions here, Mike, about signing agents and about real estate transactions. I think suffice to say that those are both outside of the scope of our authority. If you have a question about that, you may want to go to the appropriate regulatory agency, the Maryland Insurance Administration, and the Maryland Real Estate